Good morning, my lord.
Are you in London or in Dubai?
In London, my lord.
Well, good morning to you. And Mr. Al-Jabari, I see you're here. Good morning to you. Or maybe it's good afternoon in Dubai. Now, I can see a gentleman, Mohammed Ahmed. And I think, Mohammed, you are from the registry, are you not? But it's very nice to see you. We've corresponded before, but we haven't met each other. So hello
Pleasure.
to you. Now, we have two matters in particular before the court with a possible third. The principal two matters are the application for the unless order and, in substance, an application for the continuation of a freezing order that was granted on the 16th of September. The terms of that order, in fact, were that it was to run until final execution, successful execution by the claimant. But that was to overlook the necessity for a return date, so that in substance, as I think the claimants are prepared to accept, this is an application for a continuation of the order granted on the 16th of September in the same terms of that order, and it will fall for the claimants to make that application, and Mr. Al-Jabari will be entitled to resist it. Now, so far as the unless order is concerned, that in a sense speaks for itself. The claimants identify a number of orders that have not been complied with by the third defendant, and they contend that unless they are complied with, the third defendant should be debarred from being able to advance his application for an extension of time in which to appeal the judgment. And I think there may be one other application that's of a similar nature, but that can emerge in the hearing. Now, Mr. Black, so far as your application for the continuation of the injunction in the terms that it was granted on the 16th of September is concerned, I have reminded myself of the material that was relied on in support of the claimant's application that led to that order on the 16th of September. And it seems to me that in advance of hearing from Mr. Al-Jabari, that perhaps one of the principal points that Mr. Al-Jabari might wish to make is that he contends that those orders are all null and void on the basis that the court never had jurisdiction over him to make those orders or to try the action and to make the orders that are contained in the judgment. Now, it does seem to me, but I've yet to hear from Mr. Al-Jabari, the authorities are quite clear that even if there is an outstanding application subject to the unless order to challenge the jurisdiction of the court plainly has jurisdiction in the meantime to make protective orders. Orders were made prior to judgment, which were good and valid orders, notwithstanding some incipient defect, according to Mr. Al-Jabari, in the jurisdiction of the court. So I want to hear from Mr. Al-Jabari, first of all, if he has any submissions as to whether the order that is sought to be continued ought not to be made because of his challenge to the jurisdiction of the court. Mr. Al-Jabari?
Yes, Your Honor.
I'm sorry, Your Honor. I'm sorry, Your Honor. I believe I need to read out a statement.
Oh, yes, you do. You're quite right. I've rushed into it. I'm very sorry, Mohammed. Please read out the statement.
All right. Yes. This hearing is in the matter of CFI 054 2019 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Michael Black QC. The defendant is a litigant in person. Thank you.
Thank you very much.
Thank you.
So back to you, Mr. Al-Jabari.
Yes.
What do you say, if anything, about the relevance of your application to have permission to challenge the jurisdiction of the court?
Yes, Your Honor. First of all, good morning, everyone. All my application has been in the IFC. And as you are aware of, the claimant, they could not enforce any of the judgment on the mainland of UAE. So any order has been done through the DHABI the claimant, they could not enforce it by the UAE court because they've been approaching several police stations or court of Dubai or court of Abu Dhabi. Up to this moment, no one gave them the grant or to enforce that all these orders up to this moment. So, and that's one part. The other part, Your Honor, as you are aware, all my opening accounts, everything, all my dealing was happening on the mainland of UAE, of Abu Dhabi. Nothing happening in the IFC. I did not go to approach the DHABI branch or nothing to do with me over there with them. Okay, and that's the whole jurisdiction. The jurisdiction, they could not enforce it because there's no jurisdiction for DHABI on the UAE land. And the bank, they've used and abused the information but to provide it to the claimant about me without any court order. Since the beginning of that, that's why they took the claimant almost 2 years or 1.5 years to get my name only. They could not get any information about me.
Yes. Now, as is set out in the claimant's skeleton argument for the hearing today, you became a party to these proceedings on an application that you should be joined pursuant to a rule of the DIFC court.
That's true. Correct.
And
well, that's what we've been complying about.
Yes.
I never did.
Let me just finish, and then by all means respond.
My apologies.
Now, by the time the order was granted, and it was myself who made the order, by the time the order was granted, it had been established, it had become established as a matter of DIFC law that if a party, even in an international case, were joined into the proceedings under the relevant rule, then the court had jurisdiction over that party by virtue of the judicial authority law. It's Article 5(1)(a), and then a series of subparagraphs down to E. And so, in effect, and I think this was in November, Mr. Black can help me, was it the 29th of November, Mr. Black, that the order joining the third defendant in was made? Something around that time.
My lord, I'll be told in a moment.
Yes, okay, all right. At the time you were joined in to the proceedings, the jurisdiction of the court was established. Now, if you had wished to challenge that, it would have been open to you to do so.
I wish to challenge
Yes,
Your Honor, but
wait a moment, please listen. I understand you have got a lot to say.
okay.
So from whatever the date was, I believe it was in November.
21st November 2019, my lord.
21st, thank you very much, of November 2019. Since that time, the court has asserted jurisdiction over you, and the claimants would say, in accordance with the judicial authority law and a decision of the Court of Appeal that goes under the short name of Nest Investments. Now, you could have challenged your joinder into the proceedings on the basis that there was no jurisdiction to do so. By this time, you had the benefit of a well-known law firm. And the inference I draw is that your legal advisors reached the conclusion that this court had jurisdiction in accordance with the provisions that I have mentioned. Now, a very long time has elapsed since the court has asserted jurisdiction over you. And accordingly, putting on one side the unless order application, I'm not making any final determination on the jurisdiction question. That's not on the agenda for today. But I'm of the view that your challenge to the jurisdiction proceeds on the most unpromising of grounds. And the court has jurisdiction where there is a challenge to its jurisdiction if it comes to the conclusion that it is fair to do so, to make orders which are to apply and to be effective, pending any final determination of the jurisdiction. So having heard me point you to those matters, by all means respond, Mr. Al-Jabari. What's your response to what I have put to you?
I was not aware that I was under the jurisdiction of the AFC. I was aware, like lately, just now, like, less than 1 month ago. My previous legal firm, they did not inform me about the jurisdiction. They keep telling me everything's okay, everything. It's like there's, with the other party, they have no jurisdiction over you. So I did not know how to do that at that time. I was not aware of it, Your Honor.
Yes, I see. I'll just make a note of that. Now, can we look at you've served a skeleton argument, for which I thank you.
Yes.
I'm just going to turn that up. In paragraphs 16, 17, and 18, you say that there's no jurisdiction. We've discussed that. And you say the claimant is not at risk. And then you say, in reference to paragraph 74 to 77, it's premature to consider the prospect of success of the appeal in circumstances where D3 is incapable of maintaining proper legal representations to advise on the same and various other steps that it intends to take to challenge the orders made against him.
That's true.
Now, I want to examine the contention that's founded on you being unable to obtain legal representation.
Yes.
Now, as you know, I rendered a judgment directing that the firm of lawyers, BSA, that you were having conversations with about them acting for you on the appeal, could, by concession of the court, appear for you on the appeal without having to be on the record in respect of all the earlier matters, including the trial and the judgment. Now,
I didn't understand that. I'm sorry, I didn't understand that.
well, did you not? You must have read my judgment, Mr. Alpagari.
I've read it, yes.
And in that judgment, I said, you'll remember that the registry had said that unless Mr. Bowen of BSA provided an affidavit within a fairly short period of time confirming that his firm represented you and represented you in all matters, in respect of all matters, then you would be treated as a litigant in person. And you challenged that direction from the registry.
That's correct, Your Honor, because the previous counsel from the BSA, it was because I did not pay him, so he was to give me false information, so that he promised me he's going to go to the affidavit, but we need to reach for an agreement of the payment. So yes. That's why he did not do that.
Well, what it comes to is this. The impediment that the registry had imposed on you, being represented only in respect of the appeal, was lifted by myself in the pursuit of the overall justice of the case. And therefore, there was no legal impediment on you to obtaining representation in respect of your appeal based on a lack of jurisdiction. But what has happened is that you have not obtained legal representation. The freezing orders obtain a liberty to spend a stated sum on legal representation, and it would have been open to you to seek to have a variation of the sum in question. All these were matters available to you, and yet here we are at this very important juncture, and you still have not obtained legal representation. Now, can you tell me why that is the case?
I'm going to be frank. I'm going to say being truth. Every single person I've been approached to as a legal firm, they refuse to work with me without payment, as this is like big case. And when they hear the numbers, they said you need to give us some payment. As you know, the FAB has been abused, your junction, over limit. So they froze every single things on FAB I could not do. So I have no other way to get or obtain cash from anywhere. So that's step one. Step two, as you're aware, Your Honor, the claimant, they focusing on me of not to obtain any legal representative. By every time I'm going seeking any legal advisor, they've been send them a lot of tons of emails. You need to prove how, where, when, and why you are doing this to them. And I have all the communication between Clyde & Co. and the two firms I've been doing with. Even the previous legal firm, I'm having a big problem with them right now, based on that problem, that issue.
Now, you'll have seen in the recent reply skeleton argument served by the claimant, and I think it's the 7th witness statement affidavit of Mr. Hutchinson,
Yes.
that when the metadata of the your skeleton argument is examined, it was prepared by someone other than yourself. I forget the name in question, but it's a Middle Eastern name. And there was some correspondence, I think, into the registry, where you made mention of a Mr. Jonathan. And the claimants point out that there is a gentleman in BSA called Jonathan. Now, have you had, you don't have to answer this question, but have you had any help without a formal engagement with a firm of lawyers? Have you had any legal help in presenting your case today, either from this Mr. Roger or from any other lawyer?
No.
You haven't? No help at all. This is all your own. So you're
no.
This.
No, Your Honor. I said no. There's no. I did not make any firm. I just get some of the information indirect, and I wrote it down from them.
So the skeleton argument that I'm looking at, dated the 6th of December, these are all your words, are they?
No, it's not. No.
So you've had some help from somebody to
Of course,
compose
I had
this.
some help from online. I had some help from some people, like, on the legal firms, like, just like as a friendly way. They just gave me some input.
I understand. Yes. All right. Now, on the question of the continuation of the order that I granted on the 16th of September,
Yes.
we've looked at what you say in the 2 or 3 paragraphs of your skeleton argument. Are there any other matters you wish to raise relevant to the claimant's application for the injunction that I granted on the 16th of September to continue in the terms that I granted that order? Do you have any other things you want to draw to my attention?
Yes, the whole amount has been in the judge. It's already been frozen in FAB. There's no other. I'm just asking why you have been frozen everywhere. I cannot sell, I cannot buy, I cannot draw, I cannot do anything. I cannot even open an account based on that injunction. And the 64,400,000 euro is being frozen in FAB.
Yes, I see.
So I'm not understanding. So that's why I'm having difficulty to present my case, to present my jurisdiction, my appeal,
Yes.
to say, the appeal that everything was I've been framed for. So FAB is like, have 64,400,000 euro is being frozen in my account, one of my accounts. So I think that's security until we reach for a final judgment for this one.
Right. Well, now, Mr. Black, before I move on to the unless order, is there anything you want to draw to my attention which isn't currently canvassed in the 2 skeleton arguments that you've served, your first one and then your reply one, relevant to the question of the continuation of the order?
No, I don't think so, my lord. Just to inform the exchange that you had with Mr. Al-Jabri a moment or two ago, I don't know whether you and Mr. Al-Jabri have access to the updated volume C, but at page 640 of the updated volume C,
yes,
we have included Rule 12.5 of the RDC, which provides in terms that if a defendant files an acknowledgement of service and does not make application disputing the court's jurisdiction, he is to be treated as having accepted the court has jurisdiction to try the claim. The fact is that in this case, no such challenge was made. And so his suggestion now that he is able to challenge a jurisdiction is not within the rules.
Yes. Just give me the rule again. I'm aware of it, of course.
12.5, my lord.
12.5, yes. Yes, thank you. Is there anything else?
No, my lord, I think everything else that I would wish to say has already been said in writing.
Right. Well, now can we turn to the unless order application? And can you, is the draft order that you're seeking amongst the documents which are in A, B, or C? I forget. The authorities are one chapter, and the freezing order is another chapter. What I'd like to look at is the order you're seeking in the unless order, which identifies what the claimants say are outstanding orders that have not been complied with.
Yes, before one does that, my lord, I just see that Mr. Al-Jabri has left the meeting and is in the lobby.
Yes, well, that's a matter for him.
In fact, I have sufficient control to bring him back in the meeting, I think. Yes, if he wants to be.
Well,
yes, my lord. The order, the unless order, the draft order is found in Bundle B.
Yeah.
Bundle B at page 202. In case lines, that's page 16770.
Now, is there's an e-bundle posted on case lines, is there, for this hearing, or is it?
It was posted. We finally got access to it last night.
Yeah.
And after a bit of toing and froing with the order, I have all of the references both to our PDF bundles and the case lines as well, so I can give you both.
Well, it would
relation to everything.
holding on for a moment. I'm going to go on CMS. Just give me a moment, please. The case number, is it 054? I've forgotten.
I'm so sorry.
I think it is.
054, yes, my lord.
I'm so sorry, Your Honor. Sorry from the back. I'm sorry.
Mr. Al-Jabri is back, okay.
Yes, I'm so sorry for this. Something happened. I have no idea.
That's quite all right. That's quite all right. Right. Let's see. I'll go on the e-bundle. Now, when I click on e-bundle, there's a lot of case management stuff. A 13th of December hearing, I see it. And which page is it? You told me once, but I need to make another note.
So the actual draft, the application is at Bundle B, page 1, 16568. and
1658.
draft order 568, my lord.
568.
And the draft order is at 16770, which is page B202.
Okay. So I'm going to find the page. So I'm going to put in order to find the order, do I have to put B in first and then the page?
No, to find the page on case lines, you have to put in 16-770.
Okay, thank you. Yes.
So if my lord has it,
yes,
headed draft order, if one goes to the next page,
yeah,
there it sets out, as you could see in italics, in fact, what has already been ordered.
yes,
at para 2. On the next page, paragraph 3 relates to the passport order.
Are we looking at, I'm so sorry to interrupt. Are we looking at the recitals? Are we looking at the actual order?
We're looking at the order at page,
okay.
at the next page, which would be 771 or internal 203.
So the technique that's adopted here is to, in effect, repeat an order that's already been made.
What it's saying is, yes, you must comply with these orders, and unless you comply with those, so if you go then to paragraphs 5 and 6,
yes,
and 6 in particular, unless you comply with paragraphs 1 through 5, then the strikeout and the debarring. And I think one would add, out an abundance of caution, to 6B, defendants shall be debarred from taking any further steps in these proceedings and any appeal in relation thereto, except, of course, to comply with the existing orders of the court.
yes. Well, we'll come on to that.
Yes.
Now, I'm just looking, if you like, at the outstanding orders which have not been complied with on your case.
Yes.
Which, as to which the third defendant is, by this, if this order were made, is ordered to comply with those previous orders, because the substance of the previous orders are again recited in this order.
Yes.
And unless he does so, then there are to be the consequences. Now, I just want to be reminded of the outstanding orders. I'm looking at paragraph 1, the source of the funds for his spending on and so on, in accordance with paragraph 4.1 of the freezing order. Now, that
the freezing order is defined in the recitals at page 202.
And that, I see. So there was a...
So that was the 24th of November, 2019.
So that order contained a disclosure requirement that the third defendant was to disclose in writing the source of the funds for his spending. Is that right?
Yes.
I see. Now, can you give me the bundle reference for?
Yes, I can take you through. I had planned to take you through each of the orders that you had made, show you where they were.
Well, why don't you do that?
So rather, if you forgive me, rather than sort of short-circuiting things, but
No, fine, that makes more sense. Well, go ahead and take me through the orders you were going to take me through anyway.
my lord, thank you. But if we're looking at the unless, forgive me if I run forward. I was going to go to the extension first, so forgive me if I run forward to the my lord has covered a lot of ground that I was going to cover anyway, so I don't want to repeat things. My lord, it might be helpful if you forgive me if I cover a bit of the ground that you covered already, just to give you the fullest possible picture.
Go on.
Well, my lord, can I then begin at what is bundle A,
yes.
page 447, and that will be 16448.
16448.
So that is
yes,
a freezing order made by my lord on the 16th of September 2021. So that is post judgment.
Yes.
And as you see, that is the one that we were seeking to be continued.
Yes.
And my lord has already pointed out that at paragraph 2.1 that it was made until the judgment dated 30th August was satisfied, or
yes.
earlier order of the court.
Yes.
And my lord has indicated that we should take it the burden is upon us,
yes.
rather than upon Mr. Al-Jabri to apply.
Yes.
So for the fullness of my lord's note, if one then goes to page 459, which is 16460.
Wait a moment. 16460.
Yes, my lord ordered that that order should continue until today.
Yes. Yes.
My lord has already covered, I think, the points that we were going to make about the skeleton, although we would add this, that in the skeleton there is reference to paragraphs 74 and 77. The reference to paragraph 74 and 77, in fact, are references to LARMAG skeleton on the unless order. And they are found at bundle B 232, that's 16799.
Yes, all right. I'll have a quick look at that. Look, before I do, I took the previous reference to be 16460. But when I put that in, I got the order directing that both applications were to be heard today.
Sorry, my lord, the injunction, 16460, that's 459. Yes, the unfortunate thing is that since we only got the final version of the bundle last night, I'm still working from both of the forced applications we heard today. Yes, my lord, that is right. Sorry, 16460, that's correct.
But that's not what you intended to take me to, was it?
Yes, just to bring it up to date, that the injunction, clause 3 of that, the injunction will continue until today.
Oh, I see. I see. I'm with you. Yes,
I'm sorry, I didn't expressly bring you.
No,
take
okay.
you to.
No. Right, I understand. Yeah.
Yes, so it was clause 3 of that I wanted to emphasize.
Yes, go on.
So the skeleton refers to paragraph 74, 77 of LARMAG skeleton, which is 16799.
Yes.
B232. And the points that were being made there were about the merits of the appeal. And the point that I made before about the fact that Mr. Al-Jabri fully engaged in the hearing without making application to challenge the jurisdiction, as should have been the case, notwithstanding that he was represented by competent lawyers under the provisions of the RDC we've already looked at, RDC 12.5.
Yeah.
And so, as my lord, we suggest that the assertion that Mr. Al-Jabri is now incapable of maintaining proper legal representation, we challenge that both as a non sequitur. It doesn't affect what happened in the past when he was represented. And we also challenge that on the grounds that you've already adverted to and will come to, as set out in our most recent filing about the metadata on the skeleton.
Yeah.
So it is our primary position that it's really a hopeless appeal, and that does come back in later when we look at the exercise of the discretion.
Yes.
On the question of the unless order. Yes. There is a decision that I'll take you to, which I suspect.
Well, that's the Abliazov number 3, Mr. Justice Christopher Clark.
Well, my lord used the word unpromising, which was obviously Mr. Justice Christopher Clark's
right.
event.
I had that in mind when I said that.
Yes, I rather gathered that. We would certainly suggest that that is the case here. So, my lord, turning then to, again, and hoping not to repeat what has been said, my lord did advert to the order that he made on the 28th of October that if within 8 days Mr. Al-Jabri instructed legal representatives qualified to appear in the DIFC courts to act solely in the unless application, and those representatives served on the registry to claim an affidavit sworn by them confirming the instructions, they would be entitled to appear. We had no such affidavit served, and it is and has been Mr. Al-Jabri's position, and continues, as we understand it, the position that he has nobody representing him. And he's explained today that that he has no representation. But my lord has referred to our evidence on the metadata of his skeleton and the name. And can I just take you to the evidence on that, if I may, so that Mr. Al-Jabri can see it too. It is at B267.
Yes.
Now, I'm afraid I don't have the reference to that on case lines.
Well, never mind. It's on the link that the board was invited to use because of the difficulty of reconciling various references and so on.
Yes, but if my lord has that at B267, that's the exhibit to Mr. Hutchison's seventh witness statement.
Yeah.
You see that is the information section of the Word version. We wouldn't have picked this up, but for the fact that a Word version of the document was served, because PDF wipes the metadata.
Yeah.
But the author of the document is shown as Noran al-Mekhalafi, and is shown as modified by Mr. Al-Jabri, Quay Elite Holding. If one goes to the next page, there we have a LinkedIn profile for a Noran El-Mekhalafi, who appears to be an associate at BSA, the lawyers who have been acting in this case hitherto for Mr. Al-Jabri. And we make some rather strong allegations based upon this. We do suggest that Mr. Al-Jabri is deceiving the court about his ability to instruct lawyers, because this is not simply, this document does not simply show that he's received some information and drafted this document himself. This document was drafted by the author of the document.
He did tell me this morning that he had assistance and a draft, and he had then made his own contribution, if you like. He had adopted various inputs from, I think perhaps more than one lawyer, and but he'd done that. So he'd incorporated material that had come from legally qualified people, but it was still him who had, if you like, the final editorial function in presenting his skeleton argument.
My lord, we don't accept that. The physical evidence shows a document.
Do forgive me. I don't think we ought to take up too much time on this.
My lord.
At the moment, I'm going to take into account the fact that clearly Mr. Al-Jabri has had some legal assistance in drafting, in formulating the submissions that he's making today. So he hasn't been entirely on his own, a complete layman. He's had some legal assistance directed to the matters in issue for today. And
my lord, I understand the position, and I will go straight then to the chronology that I promised I'd go to.
So, you see, just to repeat, what I want to do in coming to my final conclusions on this is to look at the foundation of the applications that gave rise to these orders, which are repeated in the unless order.
My lord, yes.
In the back of my mind, I seem to remember there was some cross-examination of Mr. Al-Jabri on his assets in the trial.
Yes, my lord. I can deal with that.
Okay, and my memory is, it may be defective, that consequent on that, and quite well before the judgment was issued, an application was made to the court by reference to the evidence that Mr. Al-Jabri had given in the course of the hearing. It's that sort of detail that
I
I'm
could deal with
very
that.
much assisted with, so that I can look at each individual order to consider how important the order is and how it came about to be made.
My lord, I can assist you with all of that, and was planning to do so.
Right.
So, in which case, I will start before trial.
Yeah.
On the 21st of November of 2019, the court made a worldwide freezing order, including the usual provisions for living expenses and legal costs with disclosure obligations. You will find that in Bundle A at page 23 on case lines.
You don't give me the case lines. I've downloaded the material from the Clyde's link, so we'll stick with that. 232.
Okay.
Yeah.
Well, in that case, the freezing order itself begins at page 20.
Yeah.
And in particular, you'll see there are references to property that was known about then at paragraph 2.3 on page 22. And there was at paragraph 4.1 the standard wording in relation to living expenses and legal costs with the disclosure application.
Yeah.
That order was continued on the 24th of December 2019. And you will find the continuation order at Bundle B, page 31.
Yeah.
And the order was amended to increase the figure frozen from 7.1 million to 7.7 million euros.
Yeah, when was that? Where's the reference for that?
That is page 31.
Oh, that's page 31. Okay.
Yeah.
Now on the continuation, yes, I see.
Yes.
Yeah.
Mr. Al-Jabri failed to comply with the disclosure obligation that I referred to a moment ago. Now, prior to, so the trial took place on between the 7th and the 11th of March of 2021.
Yeah.
And my Lord's recollection is correct that following cross-examination during the trial, a further information order was made requiring disclosure in relation to assets that were disclosed at trial. Yeah. And you will find that at the order itself, it begins at page 32 of Bundle A. The specific provisions of the order are really from pages 34 through to 37.
Now, was this application made in the course of the trial or after the trial?
This was made after the trial.
Now, I want to go back and look at the material that was canvassed in support of the application. I mean, there must have been a witness statement, I imagine, and there must usually, I would expect, a short skeleton argument.
Yes,
It may be that they could be found on CMS under event.
But yes, I'm not sure that they are within this bundle.
No. Can someone on your team
certainly
I confirm that the application, the witness statement, and such skeleton argument as there were are on CMS under events and give me the details, and I can use CMS to look this up.
Yes, my lord, we'll get that information
Right.
to you.
Okay, so that's the first one post.
So that's the first one. Mr. Al-Jabri failed to comply with that order.
Yeah.
Then on the 3rd of August of 2021, the court made a further order, and you'll find that begins at page 38. But the body of the order is at 39 and specifies identified assets subject to the worldwide freezing order, and it is also within this order that the passport order is the passport order is made.
Yes.
On the 15th of August of 2021, my lord handed down judgment.
Yeah.
And it was reissued with correcting some typographical errors on the 30th of August. For my lord's note and convenience, I'm sure it's well known, but the actual order, the actual orders that my lord made during the course of his judgment, or the end of his judgment, actually begin at page 121 in bundle A.
Thank you.
Mr. Al-Jabri has not complied with any part of the judgment.
Now, can we just pause for a moment? The relief that was granted included orders for disclosure of various matters. It also included an award of damages.
Yes, my lord.
Now, at the moment, I take the view that a failure to pay damages is not a breach of an order that would give rise to an application for committal. It's not of the same character as an order directing a provision of information to assist the working out of the relief granted in the judgment.
My lord, we agree with that. The structure of the order is, of course, there is a mandatory order to give all necessary instructions for the delivery up of the 65,000 corporate bonds with FAB. That has not been done.
Yeah.
And there is the disclosure as to what has happened to the other 5,000 that were apparently paid away to a company called Zoya, which my lord will recollect. We suggested during the course of the trial was a creature of Mr. Al-Jabri's.
Yeah.
The damages are an alternative, at least in part, to the restitutionary remedy in relation to the 65,000 bonds.
Yes.
And so we certainly would not, we certainly would accept that committal would not lie for non-payment of damages. We would not accept that committal would not lie, sorry about the double negative, for failure to give the instructions to FAB to transfer the bonds back to us.
At the moment, provisionally, I think that's probably right. Well, that's it, isn't it? Because we end, I believe, with the orders that are relevant to the unless order, with the orders made in the judgment, or have there been orders subsequent to the judgment.
There have been orders subsequent to the judgment that I need to take you to as well. But so,
Yeah.
but so far as the position is at the moment and remains so, Mr. Al-Jabri remains in possession of the bonds,
Yeah.
which of course the court has found he obtained by, I quote, grave dishonesty. He's failed to disclose what became of the 5,000 that were paid away. He's failed to pay any compensation. He's failed to provide an updated asset affidavit. He's refused to hand over his passport, and he has failed to disclose the source of his funding of his living expenses and legal costs.
Yes. So can we go on to any
Yes.
orders post?
Yes, the 16th. The next one would be the 16th of September.
Yeah.
Of this year.
Yeah.
Where my lord made ex parte and without prejudice to the efficacy of any previous orders,
Yeah.
a fresh worldwide freezing order, which included, amongst other things, that the respondent must, within 3 working days of service of the order, and to the best of his ability, inform the applicant's legal representatives of all of his assets exceeding $10,000 in value, whether in his own name, etc., jointly owned. And that is to be found at page 451, or the material parts of the order are to be found at page 451.
That's still A, is it?
Mm-hmm. Yes, my lord, I'm sorry.
Bundle A 451.
It also provided that he must swear and serve an affidavit setting out that information, and it contained the usual exception about $5,000 per week, ordinary living expenses, and a reasonable sum on legal advice and representatives, subject to the usual disclosure. And as I pointed out, he's complied with none of that, nor with any of the provisions of the judgment. So that was on the 16th of September.
And I gave a short judgment.
You did, my
reasons for that.
You did, and my lord, we were going to submit that none of those reasons has changed in any way.
Yes.
On the continuation issue.
Yes.
Simultaneously with that, around the same time, was the attempted service of an application for permission to appeal. My lord will recollect that's rather convoluted, and unless my lord wants me to go through it.
No, I don't think I do.
I don't think it's necessary, save for one feature which I would respectfully submit is important in the present context, is that, in fact, a fee of $5,000 was paid to the court in relation to that attempted application for permission to appeal. And you see that evidenced in bundle B at page 190.
Yes, yeah.
And we do say that is significant when it comes to the court assessing Mr. Al-Jabri's protestations of any inability to raise funds. The subsequent history to those applications has already been set out by the court itself in the judgment, where my lord reviewed the position, of course, made the order that he referred to before. For my lord's note in bundle B at page 210, paragraphs 9 to 15 set out the history that my lord has already recorded.
Yes.
Up to 26th September of 2021.
Yeah.
So, my lord, it is our submission, turning now really to the basis of our application for the unless order against that factual background, that Mr. Al-Jabri is in serious contempt of court, and that we would be fully justified in seeking an immediate debarring or strikeout order, or indeed proceeding straight to contempt proceedings and subsequently seeking that Mr. Al-Jabri be imprisoned by the appropriate onshore authorities. Instead, we're willing to allow him one last chance to comply with those orders by seeking the unless order, and indeed my lord said there's a possibility of a third order in opening the proceeding, the disclosure order that we sought on the 7th of November of 2021. Can I just remind you of that, if I may?
But that's an order not made, isn't it? Is that an order you applied for, or was it an order made?
That's an order we apply for.
Yeah. Well, I'd like to leave that out of account.
Okay, all right, we'll leave that out of account.
Right.
So it is our submission that Mr. Al-Jabri's fate is essentially in his own hands. If he purges his contempt and complies with the orders of the court, he can be allowed to proceed with his application to seek permission to appeal out of time. And if that is successful, his application for permission to appeal itself. But we submit that if he fails to do so, the appeal notice and the application for permission out of time should be struck out, and he should be debarred from taking any further steps in these proceedings, safe to comply with the orders of the court.
Well, how long do you submit? What's the maximum time you submit that the court ought to give him to come into compliance before there is a complete barring order?
I'm just going to look at the draft order.
I don't think, is it in the draft order? My recollection is that it isn't, but perhaps it is.
My lord, we have said at paragraph 5, the order we seek is the defendant must comply with the orders forthwith and in any event within not more than 7 days.
Oh, I see. So, yeah. Well, if I conclude there is to be an unless order, I can tell you now I'm going to provide for a period that will be longer than that.
My lord, we're in your hands on that, and we understand.
In my hands on that, yeah. But I think if I am going to make an order, there's got to be some finality here, so that if I make the order and Mr. Al-Jabri is doesn't bring himself into compliance within the period of time that I've set, then there is in effect a strikeout of his applications to appeal the judgment, and he's debarred from making any further applications within the proceedings. Yeah.
Oh, my lord, that is the order that we seek.
Al-Jabri, I'm going to come to you. Don't worry, we'll take as much time as necessary with you. I'll give you every opportunity. Yes, well, I think that's then your case. Could I
was going to turn to the legal basis for our submissions after that. They are set out extensively in our written submissions, but I was going to take you to the authorities if you wish.
I've read all the authorities, and I don't think that's necessary.
Oh, I'm grateful, my lord.
Right. Now, thank you very much, Mr. Black. Now, Mr. Al-Jabri, the orders which have been made against you, with which you have not complied, are not orders that require the payment of money to the claimant. They involve some expense on your part, but they are essentially things to be done by way of disclosure. Now, that will take time and effort, but as I've said, it doesn't require you to dig particularly deeply into such resources as you are permitted to have recourse to. So, for instance, I am not including in the matters you must comply with the order for damages, which is for a very large sum. All the matters will be either disclosure or handing over items, including your passport. So that I want to bring to your attention straight away. Now, there's no doubt that these orders were made, and there's no doubt that you didn't comply with them. And the sanction for not complying with them that is sought is that if you continue not to comply with them, then you can't bring your appeal based on jurisdiction. So if you comply with these orders, you will be permitted to seek an extension of time to appeal on the basis of a lack of jurisdiction. And it's a matter for you. You're under these orders of the court, which are intended to be complied with. And if you comply with them, the way will be open for you to bring forward your application for an extension of time in which to appeal. Now, one of the questions that will arise if you comply with the orders and then want an extension of time is, when does time begin to run from? Does it begin to run from the judgment, or does it begin to run from the date in November of 2019, when you were joined into the proceedings? That'll be a matter that will have to be debated if you comply and are allowed to proceed with your application. So, Mr. Al-Jabri, enough from me. I've read your skeleton argument on the unless order, which is very clear. Are there any matters in your skeleton argument that you wish to highlight, or any fresh matters that you'd like to draw to my attention?
Yes, Your Honor.
Yes.
First, I would like to draw the attention from Mr. Michael regarding all the orders he want me to comply with. The order to hand over my passport, I cannot, it's not I don't want to hand over. There's a procedure you have to go through a UAE court to make me, for me to comply, because it's an UAE land. That's my UAE passport. I cannot hand over to the DHABI court. So that's the first part regarding the passport. I never refused to comply for any of the orders. Second part regarding the to transfer the 65 million bond to the DHABI court, I don't have any power to move or transfer or to comply with this order, because FAB has been frozen the accounts. So I have nothing to do with it. And Mr. Black, I'm not sure if Mr. Black has been aware of his colleague. They've been approaching UAE court to make FAB to transfer the bond, and UAE court refused to handle this case because there's no jurisdiction, and the bond is laying on UAE bank, not in the DHABI. So that's regarding the bond and the passport, and any other any other orders, I'm ready to challenge it. I'm ready to have the time to challenge it and, like, you know, to explain to the court why or why or yes, if I'm gonna continue or not continue. I think I need to have this right. I never had that right from the beginning of this court. I never had the right to present my case. I never had the right to bring to prove, like, all the allegation has been done by the claimant. It's all false. There is no right evidence. As you see in the beginning of this court, the claimant only focusing to freeze me and not to give me the right to appeal, or not to give me the right to have a legal representative, because they're causing me problems on the financial sector. I cannot move on. If they really have the case and they have something against me, they should not do this. This should be comfortable and, like, you know, okay, we have our evidence and we can do this. They failed to get my name for 1.5 years, Your Honor.
What can you help me with that? Sorry to interrupt you, Mr. Al-Jabri. What do you mean when you say they failed to get your name? Can you explain to me what you mean?
You know, the claimant goes to FAB and challenging FAB to reveal the name of the account of the bondholder.
Yes, I remember
for
that.
1.5 years, because they don't have my name. They don't know me. I have a different relationship with one particular party and have an agreement, and that's a debt collector. I did not have the chance to prove this to the court. That's why, you know, the claimant, they never have any chance to know me. They don't know me. Even the witness, even the emails, they failed to prove it. I never fraud or do anything to the claimant. I don't know him. I don't know him personally. I don't know him, like, you know, business-wise. I don't know him anything. He just, like, you know, person. He's been opening a war against me without nothing.
Yes.
So all the orders has been made against me is only in one direction: to freeze me, to make me fail to comply, and to make me look bad in front of the judge. All the order has been made, and which is, like, you know, that's not right. It's not right at all.
Yes, I understand.
And now they want me to hand my passport. Based on what? I'm here. I'm there. Well, why do they want my passport for? Based on what? They think I'm gonna fly away to go where? This is my country. I cannot leave my country.
Yes.
So and the bond, I don't have the power or legal or anything, because FAB have it as a custodian. They cannot move it. They cannot do anything with it. It's impossible for me to do this. Even if I send an order today to FAB, please transfer this bond to somewhere, they will immediately refer, okay, we need first of all to clear out the account. Then after that, we will see. And then you have to go to the UAE court, give us a judgment from there.
Yes. Yes, I understand.
So, I don't understand. And regarding, Your Honor, I am going to comply for any order you're going to give me, without even, giving the chance, okay? Because all the orders comes from your side, has to go through the channel of UAE court. So Mr. Michael, you have to ask his UAE team to take all this order to execute it on UAE court, which is Dubai or Abu Dhabi. And he will see, they will say there is no jurisdiction for them to comply for this order. That's why he failed up to this moment to enforce any of those orders. They did not even apply it. They only went to the police station. They said, we have a fraud case. They dismiss it. They dismissed their case. They went to Abu Dhabi court. Up to this moment, Abu Dhabi court, they tell them, no, you're not allowed to deal with us. There is no jurisdiction. There is no agreement. There is nothing between you and this and that individual. So my passport is there. I'm not hiding it, Your Honor. I never have my passports there. I'm not gonna leave anywhere. I already have travel ban from the I already have the travel ban, for I cannot leave the country, and that's the procedure in UAE. If you have something, they will do travel ban against your name until you clear it.
I see. Yes.
That's what I have said, Your Honor. And the appeal, please give me that chance to prove and present all the evidence. Though this allegation, it's not right.
Now, I have to point out to you that each time the order was applied for, not in respect of the orders, the specific orders made under the judgment, but I'll come back to those. You were given notice of the application for the order, and you were given an opportunity to put your case in writing without a hearing before the court, before myself, before I made the order.
I was not aware of this procedure, Your Honor.
Well, you see, you were
just now. I've been doing pro bono right now. I'm just trying to understand the procedure of the court of DIFC. That's now I know how to do, and now I know how to make an application through the website. Now, just now, like last week, I'm not aware of this, Your Honor. I don't know how to do it. Okay, there is an order. What should I do? I have no idea.
Well, I think in respect to some of the orders, you were still represented by your lawyers before they came off the record. But after they came off the record, you were given notice by email notices sent to your email account. And accordingly, you were given notice of the applications and the grounds for the applications, but you did not make any response. You didn't send to the court your side of the case. And accordingly, the court assessed the reasons that were given by the claimant for the order, and in the absence of hearing from you, the orders were made.
Your Honor, I was not aware. What should I do with it? I just been aware of any order I'm receiving. Now I know I can do it through the website. I don't know about it. Now I know if they make any application, then I know where to go. Even to submit my documents. Now I just been doing this through the website of the DIFC. I was not aware of this. And now I just applied for the pre bono of the DIFC to understand how to reply in the right way. I've been doing this right now. I'm doing my level best based on the situation what I am in right now, Your Honor.
Yes, I see. Yes, I see.
So that's why I could not reply to all those in writing, or even like to draw my attention for it, because I was not aware how serious it is, how bad it is, or what should I do with it. I have no idea. And my lawyers, unfortunately, the previous one, they never applied for even for one single application on behalf of me. I did not know that. I was not aware of this. Even through the trial, I did not know that. I did not have KYC or KC or the counsel to represent me in the case. I was not aware of this. I thought I go there and I start to speak and to reply to their allegation. I did not know that. My previous lawyer, he never told me this. That's why I was shocked through the 5 days of trial.
Just making a note of that.
You can, as you see, Your Honor, the previous legal representative never applied for one single application on behalf of me. Never. Not even one single application. It was only email between him and Clyde & Co, and that's it. That's why I was crazy when I saw all this right now. Everything there in front of me for the last 1 month. My case was represented in a bad way, in a bad intention from the other previous lawyer.
So I see. Well, I've got that, and there'll be a transcript of this, of these proceedings. Now, Mr. Black, in reply, what do you have to say to what we've just heard from Mr. Al-Jabari? I think you're muted.
My lord, I'm off mute.
You're not anymore. You're not anymore. Yeah.
My lord, a lot of Mr. Al-Jabari said rather ignores the fact that we've had a trial in this matter, and that he was represented by a well-known international law firm and leading counsel, and that law firm only came off the record in June. His suggestion is that they misrepresented his instructions. My lord, of course, has formed a view as to what his position was at trial. But can I just refer you to a couple of letters by that law firm that are in the bundle at the moment, which will give you some sense of what. So if you'd be kind enough to turn up bundle B and go to page 27. So this is Bird and Bird writing on the 12th of December 2019. So this is before trial.
Yeah.
No doubt on it.
Sorry to interrupt you. Did you say bundle B?
Yeah, I did.
Right. I've visually gone off the screen, but I'm still listening, and you're hearing me.
I can see you, my lord.
Oh, good. Well, I don't have the pleasure of seeing you or anybody else. So it's bundle B.
Page 27. Page 27.
And it's page 27. Okay.
So this is before trial, and let us assume that Bird and Bird were writing on instructions. And they say, in response to your question, our client does not hold any shares in Elite Holding Group. Our client does not hold any other bank account in or outside the UAE with funds in excess of £10,000. Our client has never had any personal company or joint account with Noor Bank. Our client does not hold any account with FAB Geneva. None of our clients' accounts with FAB are pledged or encumbered. And we confirmed that the enclosed affidavit disclosed all the assets of 10,000 in value. So that was serving the evidence that my lord considered at trial. And it does appear to be Mr. Al-Jabari saying now that was that somehow the lawyers were not acting on his instructions, which we suggest is improbable. And then following the position following the trial and the judgment, could I ask you to go to page 33 of the bundle? So this is now June of 2021.
Yeah.
Following trial, sorry, but prior to judgment.
Yes.
And there was correspondence from Clyde & Co. And there was request of further information. And Bird and Bird appeared to be saying that they had no instructions from Mr. Al-Jabari.
Yes.
Which again rather undermines what he told your lordship a moment ago. So we would draw those letters to my lord's attention when considering the credibility of what has been said to you this morning. In relation to other matters, Mr. Al-Jabari spoke about the procedure in relation to the courts of Abu Dhabi. We, of course, cannot enforce through the courts of Abu Dhabi until we get a final, as it were, sign-off from this court. And my lord will have seen that we've been in correspondence with the court as to whether the purported appeal prevents this court from producing the appropriate documents.
Yeah.
In relation to the position with FAB, we, on instructions, I'm told our interaction with the bank is that they will transfer the bonds if Mr. Al-Jabri gives instructions to do so, but he has not given those instructions.
Yeah.
And in relation to, my lord did ask for the references to the supporting application notice, draft order and witness statement for the 27th of May order.
Yes, and in
which
fact,
was made on, I would emphasize, that was made on notice.
Yes.
And the reference to that is to be found on the case management system as event 32, dated 6th May 2021.
Just interrupting you there, if I may, I would like similar references for all the other orders which are paid in aid, except for those made in the judgment, which are easily available to me.
Yes,
So,
my lord, we can dig those out.
Can you please?
I would just, of course, note that the 6th of May application on notice was made at a time when, of course, Bird and Bird was still on the record. They did not come off the record until June.
Yes.
And the only other point that I would that I should make or should have made earlier is to highlight that our application today, of course, includes an application for the costs of today, but also the 16th September ex parte application as well.
Yeah. Thank you very much. I'm just going to come back out of the I have quite a lot of material to consider. I must consider the submissions I've heard from both parties. I shall endeavour to deal with this as promptly as I can, given my other commitments to the court and the impending holiday. It's important that the parties know where they stand on these applications as soon as is reasonable. But as I say, I have a lot to consider, and I'm certainly not in a position to make a decision now and to give an extempore judgment. What remains to say is this: I thank counsel, and I also thank Mr. Al-Jabri for attending and for letting me have his submissions and the various reasons he's advanced. It's important that the court has had an opportunity to hear from him directly, and he tells me he now understands how to make applications and the like. And if it becomes necessary later on, he'll be in a better position to represent, to put forward his case than perhaps he was in the past. So with those words, I'm going to bring these proceedings to an end, and I shall reserve judgment on both the applications. In the meantime, the order made on the 16th of September will continue until I issue judgment in respect of the application in respect of that order.
Understood.
Thank you, my lord. And we will supply the references as soon as possible.
Yes, that would be very helpful. To have them in writing on a sheet of paper so that I can just work through them and go on to case lines to look at each of them.
May I reply to any of those orders, or what should I do right now? I have to stay still.
Well, I'm now thinking of what my judgment's going to be on the applications as to whether I should continue the order that was made on the 16th of September, particularly in the light of your case that the court had no jurisdiction for any of these matters. And I'm going to consider also the unless order, whether or not I should make an order that gives you a further period of time to come into compliance, so that if you do, you can then go straight on with your appeal application.
Okay, thank you.
So I'm going to, good. So I'm afraid in the meantime, everything stays as it is, including the order that I made on the 16th of September. So thank you very much indeed.
Thank you, Roland. Thank you.
Thank you. Goodbye.
Thank you, Mark. Bye-bye.
Bye-bye.